My lords, before I start on first, might I inquire whether the court would fancy a break at some stage in the afternoon, and if so, when?
Well, I think probably about 3:15.
Very good, my lord. I'll work on that basis. Right, I was going to take the court to a churus, starting at paragraph 33, which is in Authorities Bundle 12, tab 51, page 2003. And if we look at paragraph 33, we see what the court is discussing. Paragraph 33, presumption of causal connection between a consultation and the market conduct of the undertakings participating in practice, according to which those undertakings, where they remain active in the market, take account of the information exchanged with competitors in determining conduct in the market. That's straight Anic. Now, if we look at paragraph 34, then what happens there, if you read that paragraph, it parks the Anic assumption for the time being to focus on the evaluation of the facts, whether there was consultation in the first place, and that's principally a matter for national law. And then if we look at 35 to 37, there are familiar principles set out around the drawing of inferences in that context. Paragraph 38 introduces the presumption of innocence to the factual inquiry, directed at the first element of a concerted practice, namely consultation. Paragraph 39 says presumption of innocence precludes the referring court from inferring from the mere dispatch of the message at issue. In the main proceedings, the travel agencies concerned ought to have been aware of the content. Paragraph 40 says that the presumption of innocence doesn't preclude the court from considering the dispatch of the message may, in the light of other objective and consistent indicia, justify the presumption that they were aware of the content. Paragraph 41 sets out that if there is going to be a presumption that they were aware, it can't be irrebuttable. It must be realistically rebuttable. So far, so good. That's all about proof of the consultation and the fact-finding process that is governed by national law. Paragraph 43 turns back to concerted practice within the meaning of Article 101, and it sets out in paragraph the three elements. Paragraphs 43 to 45 analyse the facts within the framework of the first element, namely consultation. That appears clearly from the first sentence of paragraph 44. Those circumstances are capable of justifying the finding of consultation between the travel agents which were aware of the content of the message. And also from paragraph 45. So we're talking about consultation. Now, paragraph 46 then moves from consultation to the presumption of participation in an infringement.
Well, that's the question, isn't it?
No. With respect, my lady, it talks about rebutting the presumption that a company has participated in an infringement. And in order to get participation in an infringement...
Sorry, you're reading from...
46, my lady. So there are two things being dealt with in 46. There are ordinary proceedings where there is a meeting, and there are these proceedings which don't involve a meeting. And the question is, as it says, about 5 lines down, in addition, according to the case law of the court, in a case such as that at issue in the main proceedings, which does not concern an anti-competitive meeting. Public distancing or reporting to the administrative authorities are not the only means of rebutting the presumption that a company has participated in an infringement. Now, to involve participation in an infringement, there requires to be three elements: consultation, market conduct, and a connection.
The first reference to the presumption in 46 is in this first and second line, which talks about presumption not of infringement but participation in a concerted practice.
Yes.
In language which is not dissimilar to the last part of 44, presumed to have participated in that consultation. And I think you said you agree that 44 at least is about the first element.
Well, what I say is 43 and 44 are about the fact finding that a court engages in order to establish whether there was consultation at all. That's what those paragraphs are concerned with. And 46 is dealing with So 46 is saying the participation in a concerted practice amounts to an infringement. Now you only get to that to do an infringement if the three elements of consultation are present. (47) in this judgment considers how public distancing might be achieved in the special fact circumstances of this case. And obviously, public distancing, where there hasn't been a meeting between the competitors, is going to be more problematic than public distancing where there's simply a face-to-face meeting. Paragraph 49 deals with the rebutting the presumption of participation, which we all agree is the Anic presumption, by means other than public distancing, reporting to the authorities. And that's where it's held that there are other means in this particular special case of rebutting the Anic presumption. So it's in that case that we identify the difference between two kinds of cases, one involving a meeting where the presumption of participation, including causal connection, can only be rebutted by public distancing, in cases not involving a meeting like this, where other evidence can be used to rebut the presumption. You can do it by public distancing, but that's problematic in a case like this, or you can do it by other means. Now,
it's interesting that in the fourth line of 49, it's very clear which presumption is being referred to, presumption of causal connection.
Yes, and it refers back to paragraph 33, which is where we started with the Anic presumption. So our submission about this is as follows. 46 sets up the distinction for rebutting the Anic presumption between cases concerned with an anti-competitive meeting and cases which do not involve an anti-competitive meeting. In the latter category, there are two options to rebut. One, public distancing, including report to the authorities. When I say public distancing, my lords and my lady, I'm also including within that, obviously, report to the authorities. I'm simply using a shortcut. Paragraphs 47 and 48 address the first option, how public distancing may be achieved on the unusual facts of this case. And paragraph 49 picks up on the second option. So we submit that the idea that there is some form of disjunct between paragraphs 46 and 49 of the court's judgment doesn't stack up.
How does that fit with the logic? I can understand that if you're in a meeting and you're silent while your competitors are all agreeing to fix prices.
Yeah.
that public distancing may be required. That's going to the first element, consultation. That makes perfect sense to me. It doesn't make the same level of sense to me to say that when you get to the third element, the true Anic presumption, the paragraph 121, causal connection, what's the sense or logic there for saying that that has to be addressed by public distancing where there's been a meeting? Where's the logic?
The logic, obviously, my submission comes back to the guiding principle in Sauke Unye. Strictly precluded a direct contact between competitors with the object or effect of disclosing to or influencing the conduct of competitors. That is, prima facie, very bad. Now, in those circumstances, the law says if you want to dissociate yourself from the unlawful conduct, you have to public distance.
Because public distancing is shorthand for
It is.
something. If, for example, in our case, Mr. Swansea had stood up whilst Mr. Dunn was making this proposal and said, "I'm not having any of this. I don't want to see you again. Goodbye," and walked out of the restaurant.
Yes.
That would be public distance.
It would.
And in that situation, there couldn't be any argument that there was tacit approval or anything of that kind.
Absolutely.
And that's the point.
As I've already submitted, that wasn't his last chance. He also had the opportunity, when he got back to the office and thought about it, to send a letter clearly stating that they would have nothing whatsoever to do with this and rebutting any suggestion that they would act cooperatively with Mr. Dunn. But as I've shown the court, judgment 227 tells you why it is that Mr. Swansea chose not to follow that option. He was concerned about commercial reasons, and he took the risk. And as I say, the risk has come home to roost in this case. Now, I want to show you what the Supreme Court said about this, because in my submission, the Supreme Court had no difficulty at all in seeing that 46 to 49 in this case were talking about precisely the same presumption, namely the Anic presumption.
Right.
And that is to be found in tab 24, volume 6, page 1159.
Yeah.
Now, we are going to look in the first instance at page 1160, which sets out the various points of appeal, and if you could go down towards the bottom of the page, just at J, I think it is. Two issues arose in that regard. One, whether the court was bound by MasterCard's CJ, and if not, whether that decision ought to be followed. Secondly, this is the important one, whether the Court of Appeal found, and if so, whether it erred in law in finding that Visa and MasterCard were required to satisfy a more onerous evidential standard than that normally applicable in civil litigation in order to establish that the MIFs were exempt from the prohibition on restrictive agreements pursuant to Article 1013. So that sets the appropriate issue for our purposes. And if we look down towards the bottom of page 1161, towards the bottom of the page, just above J, you'll see that it starts, as a result, although the standard of proof was a matter of domestic the nature of the evidence that would satisfy the standard had to take account of the substantive requirements of Article 1013. While EU law had deferred to the law of the member states in respect of the standard of proof under Article 1013, subject to the principles of equivalence and effectiveness, it clearly maintained its own requirements as to the type of evidence that could be capable of discharging the appropriate standard of proof. Now, we can then turn on to page 1187. And if we go down to J, the context here is the nature of the evidence that could be deployed to satisfy the requirements of Article 103. And that was an important point of competition law for the Supreme Court to resolve on appeal. And the resolution of that issue required, as we shall see, the court to consider and interpret ituris. Now, we see from paragraph 112 that Visa and MasterCard relied on a passage in the decision in ituris, which I've not yet taken, which I haven't taken you to. We can see what what was being submitted if we turn over to 113 on page 1188. So MasterCard has cited the decision on a particular paragraph about the standard of proof. And the Supreme Court says this at 113. This passage, however, is not as helpful to Visa and MasterCard as might first appear. The issue in that case, which was a reference from the Supreme Administrative Court of Lithuanian proceedings where an anti-competitive concerted practice was alleged, was whether certain evidence was sufficient proof of a fact which, if established, would trigger a presumption of liability under Article 101. Passage in a judgment of the Court of Justice was concerned with a specific question whether the dispatch of a message through an electronic system may constitute sufficient evidence to establish that the operators which use the system were aware or ought to have been aware of the content of that message. And surprisingly, the Court of Justice held, in accordance with the principle of procedural autonomy, the standard of proof in relation to establishing that fact was a matter for the national legal order of the member state concerned. And pausing there, I've taken the court through the various paragraphs from 33, 40, and in the 40s. So it says the Court of Justice went on, however, at paragraph 33, to distinguish the presumption arising under Article 101 of causal connection between a consultation and the market conduct of the undertakings participating in the practice. That presumption, it emphasised, followed from Article 101 and consequently formed an integral part of the EU law, which the national court was required to apply. The Court of Justice then went on at paragraphs 46 to 49 to address in detail the nature of the evidence that would be sufficient to rebut the presumption. Now, it's perfectly plain in my submission that the Supreme Court was treating paragraphs 33 through 33, 46 and 49 as relating to the rebuttal of the Anic presumption, not some other presumption. And then continuing in paragraph 114, in our view, the fact that the Court of Justice in ituris addresses a question of EU law, what evidence was capable of rebutting the presumption of participation in a concerted practice, provides the key to resolving the issue in the present case. In that case, the Advocate General observed, with regard to rebuttable presumptions and competition law, insofar as such presumptions stem from Article 101, as interpreted by the Court, and consequently form an integral part of applicable EU law, they do not fall within the scope of the principle of the autonomy of national procedural law, and are therefore binding on national authorities when they apply EU competition rules. As Mr. Khan QC, on behalf of the Commission, put it in his oral submissions, ituris illustrates how the nature of the evidence by which a finding of infringement can be secured or rebutted may be a question of EU law. In the same way, the nature of the evidence by which an undertaking may establish that the restriction on competition is exempted by virtue of Article 1013 may also be a question of EU law. Now, as I've submitted, the Supreme Court refers in terms to the presumption of a causal connection between a consultation and the market conduct of the undertakings participating in it. That is to say, the Anic presumption. And in my submission, that could not be clearer from the final three sentences of paragraph 113. Now, in our submission, against the background of this clear interpretation and application of a jurist by the Supreme Court, EE is forced to argue that even if the CJEU was addressing the Anic presumption, when it said what it did in a jurist, it was obiter and for good measure wrong. With respect, we submit that neither proposition is tenable. First, the CJEU's treatment of Anic was not obiter. The court had to determine how the presumption could be rebutted. To do that, it had to identify and determine both the general rule and the exception to that rule in a case such as a jurist, which did not involve a meeting. That was all part, in our submission, of the chain of reasoning by which the court reached its conclusion and answered the questions referred. As far as the decision being wrong, that, with respect, is hard to follow. Common ground, as I've shown the court, that the Anic presumption forms part of the substantive law of Article 101. These proceedings relate to events before Brexit, so there's no question domestic competition law departing or diverging from the law of Article 101, as interpreted by the CJEU, on a reference for a preliminary ruling. Wrongness is not an attribute that a CJEU judgment interpreting Article 101 can possess, unless it has been subsequently overruled. It states the law of Article 101. Now, it doesn't avail EE to suggest that the statement of the law is illogical. Not remotely illogical in our submission to have a strict rule, as I've said, that applies in the ordinary case of a meeting involving an anti-competitive meeting, and perhaps a more permissive rule for unusual fact patterns such as those in the juris. But even if the distinction were somehow illogical, as I've said and submitted, the decision in a juris is an authoritative statement of the law. My next point is to note that EE say, well, even since a juris, the court, CJEU, has spoken of Anic being capable of being rebutted by proof to the contrary, without specifying what type of evidence would suffice for that purpose. Perhaps if we could bring up EE's submissions, which is at paragraph 90 of the core bundle, page 90 of the core bundle, tab 4, paragraph 29b. And if you look down, you see about 5 lines down, moreover, you see, moreover, post the juris, the CJEU has continued to express the possibility of adducing proof to the contrary to overcome the Anic presumption in general terms. See Scania. If Phones for You are right, it should instead have explained that any form of proof is permissible for certain classes of consultation, but the relevant type of proof is restricted to public distancing. Now, the short answer is that the CJEU has not had to do so because the point hasn't arisen in a way that required a decision that might conflict with the juris. There isn't a single CJEU case before the court since the juris in which the Anic presumption has been rebutted by evidence other than public distancing or report to the authorities. There is therefore no subsequent case that could be read as effectively overruling the juris on this point. The second point is if we can look at the case of Scania cited by EE, it does not suggest that evidence other than public distancing can in fact be relied upon. We have that case of Authorities tab 59, page 3428. It's the Scania Trucks case. The relevant passages, my lords and my lady, are at page 3449. If you could turn to that. And if the court could please read paragraphs 99 to 103. So what you have in paragraph 99 is a general statement that passive participation in an anti-competitive meeting establishes consultation. Non-objection is sufficient. Paragraph 100, a statement in the conventional terms of the role played by the Anic presumption, satisfying the other elements of a concerted practice. Then in paragraph 101, in order to avoid liability, it has to prove that the undertaking intended to take part in the infringement, but that it is for the undertaking to provide evidence of its distancing itself from those agreements. Now, it doesn't specify that only public distancing can rebut the Anic presumption, but the only method identified here is distancing. Now, far from showing a retreat from the principles in Echurus, in our submission, it's consistent with early authority. Scania makes clear that passive participants in anti-competitive meetings are presumed to be parties to a concerted practice unless they public distance. And that is contrary to EE submission's authority in our favour. Now, perhaps we should look briefly at how the learned judge dealt with this in paragraphs 25 to 26 of the submission judgment, core bundle 2, tab 19, paragraphs 25 and 26, which is on page 469. So the first point made by, and it's headed ground 3 because the grounds were numbered differently at that stage. Paragraph 26, I've already dealt with this. The judge says we didn't make the point at trial. That was wrong. I don't need to go back to that.
Yeah.
Now, the learned judge, in paragraph 27, page 470, although not expressed in that way, it may be that this ground of Fainsfield's appeal should be understood as a submission, but in this regard, EU law has developed since those cases, since Fainsfield lies on what the CJU and Advocate General said in the Churus. I accept it's arguable, although since the Churus did not concern a meeting, what was said there on this point is clearly overturned. Well, I've already addressed you on that. We disagree with that. But as the Advocate General explained, the development is based on policy reasons which apply only when an undertaking participated in a meeting or meetings at which an anti-competitive agreement is concluded between the other participants. Now, we have set out in our skeleton argument authority to the effect that principles of law set out by the CJEU on a preliminary reference are declaratory of the law of Article 101, as it has always been, rather than making new law. And I'm not going to take time by taking it up, but that's in paragraph 57 of our skeleton argument. So when the court declares what the Article 101 means and requires, that means it has had that effect since the beginning of time. But it's nevertheless important to notice that a churus didn't involve any dramatic change, and I say that because no undertaking has in fact ever rebutted the Anic presumption through reliance on, in the CJEU, through reliance on facts other than public distancing. Now, I've also shown you that in paragraph 27, the learned judge referred to a meeting at which anti-competitive agreement is concluded by the other participants. But that isn't what the CJEU's judgment in a churus says or can reasonably be taken to mean. And we need to go back then to paragraph 46 of a churus, 3005, in the authorities bundle 12 and 51. So, in paragraph 46, we see that the court says, in the third place, it must be pointed out that a travel agency may rebut the presumption that it participated in practice by proving it publicly distanced from that practice or reported it to the authorities. In addition to the case law of the court, a case such as that at issue in the main proceedings, which does not concern an anti-competitive meeting, public distancing or reporting to the authorities are not the only means of rebutting. But there is nothing which suggests or can be taken to read, as the judge seems to think, that there needs to be an agreement in such an anti-competitive meeting. That's not what the court says. In order to give rise to a concerted practice, you don't have to find that there has been an agreement between the parties. That's why we have the concept of consultation. Now, the only other possible avenue for supporting what the judge has said in his permission judgment is to say that the strict rule requiring public distancing doesn't apply where the meeting has only 2 participants rather than 3. But in fairness to the judge, that isn't something he suggested himself. It's not supported by the authorities, and it's not supported by the CMA. As we pointed out in closing the trial, some of the meetings at issue in the case of Tate and Lyle were bilateral only, but this doesn't appear to have affected the reasoning of the court of first instance in that case. And I can just give you the references to the appropriate passages in the judgment in Tate and Lyle. It's tab 38 of the authorities bundle, at paragraphs 9 to 11 of the CA Court of First Instance judgment, pages 2210 to 2211. Now, lastly in the permission judgment, the judge refers to the case of Solvay. One sees that, Core Bundle 2, tab 27, tab 19, page 470, where the learned judge refers to the case of Solvay, about halfway down the paragraph. He says that's inconsistent with phones for use submission. And in Solvay, an attempt was made to rebut the presumption by showing the information exchange didn't have any influence on its conduct, since its prices of the products in question had decreased in the market and remained highly competitive. And unsurprisingly, the court held this alone was not sufficient to displace presumption. Now, the learned judge is right to observe that in the Solvay case, the court said that certain evidence other than public distancing was on the facts insufficient to rebut the presumption, rather than saying that the evidence of that type couldn't suffice. But a number of problems with the idea that Solvay trumps Atturus. And perhaps we could have up the Solvay case, which is in volume 11, tab 47. I've got the wrong reference, forgive me.
No, that's right.
I'm right.
Solvay.
Yeah, it's misplaced. Sorry, Now, as I said, there are a number of problems with the idea that Solvay trumps Atturus. One, Solvay isn't a case in which evidence other than public distancing, in fact, rebutted the Anic presumption, or where the CJU, even on its terms, stated that such evidence would be sufficient. The court considered the material relied upon by the appellant and concluded that it could not rebut the presumption. But it would not be unheard of for a court to consider and reject an argument on the facts without saying on the facts, even if made out, couldn't have satisfied the legal test.
Wouldn't the second of those be a much easier option?
It might have been, but what is easier doesn't always follow, as your ladyship will see from some of these judgments. But a more important point is this, that Atturus postdates Solvay, and as a matter of authority, Atturus takes precedence. Now, for completeness, it doesn't appear from the case that the appellant in Solvay was in fact contending that it could rebut the Anic presumption. Rather, it seems to have been arguing that it hadn't engaged in consultation at all. So, if we turn to page 2718 of the court's judgment, you'll see at paragraph 33 what Solvay was submitting. Can I invite the court to read paragraphs 33 and 34? So the court sees there the argument that Solvay was running. And then if one turns to paragraph 42, we see the way in which this is dealt with by the court. So you see there at the beginning of the paragraph 42, as regards Solvay's argument, the general court failed to take account of its observations, but the information exchange was not sufficient to have negative effects on competition. So that was the argument, no consultation. It should be borne in mind that the Court of Justice has held that, subject to proof to the contrary, which the economic operators concerned must adduce, it must be presumed that the undertakings taking part in the concerted action, remaining active on the market, take account of the information exchange with their competitors in determining their conduct in the market. So you have the argument you've seen in paragraphs 33 to 34, no consultation at all, And that argument is rather skipped over by the court in essentially ignoring that and moving straight on to the Anic presumption. So even if you look at this case in isolation from Achuris, it isn't, in our submission, compelling authority for a submission that the Anic presumption can be rebutted by evidence other than public distancing. The CJEU didn't find the presumption to be rebutted, and it seems that its argument of the applicant was that the presumption didn't apply in the first place. So that's that. There is another case which is relied on by my learned friends, namely Tesco. I'm not going to take the court through that, but say this about it. It is true that in 2012, the Competition Appeal Tribunal found that the Anic presumption could be rebutted by means other than public distancing. 3 points about what the tribunal did there. First, it's a first instance national court. It can't trump CJEU authority. The decision was back in 2012 before Achuris, and the decision now is effectively per incuriam in our submission if you accept our submissions as to what Achuris requires. The third basis on which it found that the presumption could be rebutted as regards certain information that had been illicitly shared was that the information had effectively become publicly available before it could have been any use to the participants in the consultation. And the reasoning seems to have been that this was relevantly analogous to a situation in which the relevant undertaking had left the market before the information could influence its conduct. That's paragraphs 276 from the note to 278 on page 690 of the authorities bundle. But there is no analogy with our facts. And in any event, the main point is that Tesco is inconsistent with subsequent CJEU authority and, for good measure, in our submission, the Supreme Court's interpretation of Achuris and Sainsbury's. Now, if I'm wrong, or if we're wrong, that the public distancing isn't the only means of rebutting the presumption, and that other evidence can be relied on where we're not concerned, where we are concerned with a meeting, there is a further alternative argument, and it is alternative, it was very clear in our skeleton argument at paragraph 60. Assuming then that you can rebut by means other than public distancing, what facts must be proved to rebut the presumption? And the clearest answer to that is that Solvay case we've just been looking at, volume 11, tab 47, page 2720. Page 2720, paragraph 42. We turn to paragraph 43. I've already read you 42 already. In order to rebut the presumption, it's for the undertaking concerned to prove that the concerted action did not have any influence whatsoever on its own conduct in the market. The proof to the contrary must therefore be such as to rule out any link between the concerted action and the determination by that undertaking of its conduct on the market. Now, this is another aspect of which the CMA agrees with us, and we could look at, please, their document at Hall Bundle 2, page 1001, paragraphs 65 to 66. 65 on page 1000, the CMA agrees with Phones for You that the threshold for rebutting the Anic presumption is the one laid down by the Commission, by the court in Solvay, where it held 43 and 44, and cites the passages we've looked at. In the CMA's submission, the rationale for the Anic presumption means that it will be rebutted in relatively rare cases where there is cogent evidence that there is no causal link between the consultation and an undertaking's conduct on the market. As the court observed in Solvay, the evidence must be such as to rule out any such link. That is a high bar. And if we look at the facts in Solvay, which were held to be insufficient, we go back to Solvay, paragraph 44 to 45. Could I invite the court to read to itself those particular paragraphs? And you'll see that the bar is indeed a very high bar, because you see in the last sentence of paragraph 145 that even if it were established that the exchange of information in question had no influence on prices during the period concerned, that would not call into question the legality of the Commission's findings. Now, we can see from the report of the General Court's judgment in paragraphs 161 to 162, tab 46, please, page 2675, paragraphs 160 to 161, sorry, 161 to 162. Even if it were established that conduct had no influence on prices during the period, that would not call into question legality. In particular, the fact that a concerted practice has no direct effect on price levels does not preclude a finding that it limited competition between the undertakings concerned, inter alia, by eliminating competitive pressures. So, what we have in the event that we are wrong, that public distancing is required, an extremely high bar set by the decision in Solvay, which of necessity is for the MNOs to discharge that burden. Now, EE, in disagreement with the CMA, objects to Phones for You's reliance on Solvay on the basis that there is only one standard of proof under English law, namely the balance of probabilities. That is, of course, correct. But the fact is, in Solvay, the CJEU has identified the facts that must be proven to the standard of balance of probabilities. And those are facts which rule out any link between consultation and subsequent market conduct, and show that the consultation had no influence whatsoever on that conduct. Now, in our submission, that is similar to the distinction drawn by the Supreme Court in the Sainsbury's case that I've just shown you. The law of Article 101 specifies the facts that must be proved, and even in the nature of the evidence by which they can be proved, but that is distinct from the national standard of proof to which those facts have to be established. And we don't need to go back to it. That's paragraphs 113 to 116 of the judgment in the Sainsbury's case, Authorities tab 24, pages 1188 to 1189. Back to the CMA again. In Court Bundle 2, tab 27. paragraph 68, which you find on page 1001. Well, it's now moved to 2002, forgive me. The CMA agrees with that the standard of proof for rebutting the presumption is the balance of probabilities. But that standard does not dictate what must be shown as a substantive matter of competition law, which is set out in Solving. And the CMA doesn't make submissions about it, or the judge was right to find it rude and rebutted. So, the burden on those seeking to rebut the presumption is set at a very high bar by the Solvay decision. Yes, you have to prove that on the balance of probabilities, but you've got to at least to make the run at trying to surmount that burden. And that didn't happen in this case. Now, if we look at how the judge dealt with this in his judgment, and turn to paragraph 232, which is on page 320, Core Bundle 1, tab 18. He says, I conclude that EE was not a party to a concerted practice, since it must, by definition, involve more than one party. That effectively means that O2 was not a party to it. In any event, the presumption of reliance as affecting conduct on the market does not apply to the party disclosing the information. And as I find, Swanty made no disclosure to Dunn, nor did he offer to give any support. I don't see any scope for the presumption to apply to O2. Now, as I've already addressed you on whether the judge was right as a matter of law, and he says not to consider whether the presumption applied equally to EE and to O2, but having made clear that he didn't regard the presumption as applying to O2, it was clear that he was giving no role to Anic, and therefore to rebutting it. And he doesn't say anywhere in the judgment that had, contrary to his judgment, the presumption applied to O2, it could have rebutted it. Now, the judge seems to imply in his reasons for refusing permission, tab 19, Core Bundle 2, at page 472, paragraph 31, he says further, and in any event I held that even the presumption applied to O2 such that O2 failed to rebut it. So he seems to be there suggesting that even if it had applied to O2, O2 would not have rebutted the presumption on the facts, which is what the words in parentheses seem to suggest. That must be right in circumstances where O2 focused its submissions on trying to demonstrate there wasn't any connection between the consultation and EE's subsequent market conduct rather than its own. For example, paragraph 58 of its written opening, supplemental bundle 2, tab 26, page 592, but I don't need to take you to that. The whole purpose of this meeting from Mr. Dunn's perspective is to de-risk the conditional decision to exit, and in that regard to sound out his competitor on O2's planned strategic move against the indirects. And we also know that Mr. Dunn was left with the impression that EE was not objecting to or was wholly uninterested in cooperation. And in our submission, it's wholly inconceivable that in those circumstances, that information had no influence whatsoever on O2's subsequent decision-making. So, on the footing that the judge was wrong, and the Anic presumption did apply to O2, in our submission, there was no serious basis for suggesting that it was rebutted, regardless of the correct test, be it Anic or Solvay, forgive me, rather public distancing or something else for rebutting the presumption. Now, as far as EE is concerned, again, that's a matter the judge deals with in 231, page 328. He says that EE has rebutted the presumption on the facts. Now again, he was wrong, they had the public distance, but even if that was open to them, they had to shoulder the burden solely to show that their decisions were completely uninfluenced, no influence whatsoever by the meeting that they had on the 19th of September. Now, the judge says that in the last sentence in 231, I do not think that phones for you really suggested that the exchange between Dunn and Mr Swanty influenced EE's conduct on the market. Well, that's not quite right. If we could look at phones for you's written closing, extracts which are in the supplemental bundle volume 2, you'll see what we said, and that is supplemental bundle 2, tab 27, page 606. And could I ask the court, sorry, 609, could the court read to itself paragraphs 35 through to 39? Now, in our submissions, we were trying to persuade the judge, in accordance with Solvay, that we couldn't rule out direct or indirect links between the consultation at the lunch and what subsequently followed. And as I said, Solvay makes clear that the presumption would not be rebutted unless all potential links and types of influence have been ruled out. And the judge's reasoning in paragraph 231 failed to address Phones for Use case that the mere fact of a long delay between the consultation and market conduct does not rule out an influence, especially in market conditions which pertain here, where the relevant contracts had long fixed durations and weren't necessarily synchronized. So if O2, having got comfort from Mr Swanty's reaction at the meeting, decided to exit phones for you, it did not follow that EE would be able immediately to follow O2 due to the asynchronous nature of their contracts. But as we shall come on to see, once O2 had left, the prisoner's dilemma still remained for both EE and Vodafone, but it made it a lot easier to deal with if they thought that O2 wouldn't be coming back into the market. All that would be needed in those circumstances was, again, a degree of comfort given informally from one to the other as to what their intentions in relation to phones for you was. So saying that EE stuck with phones for you in the short term, and perhaps even increasing the volumes, is to miss the point that that might rule out an immediate impact on EE's market conduct, but it could not, in accordance with Solvay, rule out any influence whatsoever. Now, if we look at what the learned judge had to say in his permission judgment, back to Paul Bundy, 2:10:19, at paragraph 28, 471.
Sorry, just before we
Yes,
go on, you're here talking about the potential reduction, or what, put it this way, what EE got out of the meeting from O2,
Yes.
not the other way around.
Yeah.
But on your first ground of challenge, ground one, you've clarified that you're not, as I understand it, trying to challenge the judge's findings in relation to what EE
Yes.
got from the meeting. Too vague, from 2217, too vague to remove uncertainty. If you're not challenging that, where do you get to with the point you're making now?
Well, where we're getting to with that point is that when it comes to assessing whether the Anic presumption applies and can be rebutted, first of all, both undertakings, if they want to escape the Anic presumption, have to engage in public distancing. The same would be true for EE as it would be for O2. And that wasn't. The judge didn't apply the public distancing approach to EE. He held that it could be rebutted on the basis of his findings, but in the alternative, but he didn't follow the approach in Solvay. He didn't hold EE to the bar of establishing that you had to rule out any link whatsoever between the consultation and the subsequent market conduct. So the fact that EE hasn't derived anything doesn't mean there's not consultation. Yeah. And what happens ultimately is that while EE may not have derived anything useful in the immediate term, what it will derive ultimately is the knowledge that O2 has exercised its strategic plan to exit from Phones for You. So while it may not have an immediate benefit, it gets the long-term benefit, which has to be excluded on the basis of Solvay, And we do know, as I said earlier, that O2 did not come back. So what Swanty knew at the meeting is that he was being invited to collude. And additional information which Swanty got once O2 was out of the market is the knowledge that it was unlikely that O2 was coming back, as indeed happened. He could say to himself and to EE, well, as a result of the meeting that I've had with Mr Dunn, I'm pretty confident that the decision which O2 has taken partially to exit from phones for you isn't going to be reversed. Otherwise, he wouldn't be approaching me in the first place at the lunch. And we know from the judge's judgment that the past experience of these MNOs was that the decision in 2006 by Vodafone and by O2 to leave either car phone warehouse phones for you had in fact been reversed. Now in this case, on the basis of the a meeting which Swanty had had with Dunn, and subsequently finding out what had happened, that also reduced the competitive uncertainty. And in order to show that that consultation had no effect on the parties' conduct, they had to satisfy the Solvay test. And on our submission, no attempt was made to do so. Now,
having some difficulty on the judge's findings that the remarks are too vague to remove any certainty in EE as to O2's future conduct. How that you could therefore say that subsequently Mr Swanty had knowledge that O2's decision would not be reversed.
well, one of the elements of uncertainty that Swanty had at the meeting was, you're talking about car phone warehouse, or you're talking about phones for you. And what he would have discovered when it became public knowledge was that it wasn't a car phone that we were thinking about, it was phones for you. Now that, taken in addition to what he did know, he was been invited not to take volume, he would have known that this step in my submission was a strategic step. Otherwise, there's no point in Mr Dunn approaching Mr Swanty at all. And as I've said, the evidence...
I might be missing something, but why does that mean it won't be reversed?
Why does what?
Why does that mean it won't be reversed?
It doesn't mean it won't be reversed. I have to accept that. It doesn't mean it won't be reversed, but it makes it less likely that it will be reversed. And that is a reduction in competitive uncertainty, which Article 101 is intended to prevent.
I think you're saying that because the fact of the approach meant that what became clear in publicly clear later, which was there was an exit by O2, you're saying when that is put together with the approach at the meeting, that somehow adds up to more than a pure exit, which is obvious from what happened publicly.
Yes, I do.
And somehow amounts to a clearer strategic message that we're not only coming out, but will not go back in.
Yes, I am saying that.
Despite having this finding, which I'm still not clear that you're challenging in 217, that it was too vague.
217 or
217.
218
208, I think it is, my lady.
But it's
Your ladyship's right. he says it doesn't benefit EE. What was said at the meeting doesn't benefit EE, he says. But let's look at it this way. There is no doubt that Mr. Dunn told Mr. Swanty, as is recorded in the notes following the meeting, that he was planning on playing some big cards.
But are you not challenging that last sentence of 208? Because you are saying it does remove uncertainty as regards O2 strategy.
In the short term.
You're saying it removes uncertainty in the long term.
Yeah. When taken with the fact of exit in the long term, that is a reduction in competitive uncertainty.
So is that a challenge to the judge's finding of fact?
I'm not sure it is, my lord. If we look at 208, so what he's saying there is it doesn't remove the uncertainty at the stage of the meeting as to what those big cards were. Although, as we know from paragraphs 197 and 199, he understood the thrust of what was being said. So the thrust of what was being said was, we're planning to play some big cards, and we don't want you to hoover up the volume. That's what the thrust of what was being said. What the judge is saying here, at the meeting, what was being said was unclear at that stage what those big cards would be. However, if we get to the stage of suggesting that the Anic presumption has to be rebutted, we know that the big cards which were being played was an exit from Phones for You. And that, in our submission, is enough to establish that when it came to rebutting the presumption, O2, EE, had to go further than merely sitting on its hands. That was a benefit that it obtained, which it would not otherwise have obtained, apart from this meeting on the 19th of September. So,
the difficulty with all this is that, and what the judge says at paragraph 28 of the permission judgment, is that it was never put to Mr. Swanty that when he was considering later whether he should leave,
yeah.
he had regard to what Mr. Dunn told him in 2012.
Yes.
And then the judge clearly didn't like any of this, because he says any suggestion Mr. Dunn gave Mr. Swanty to understand in September 2012 that if O2 exited from an indirect retailer, it would never, irrespective of market developments in the future, decide to resume its relationship with the retailer is frankly preposterous.
Yeah, that's putting it too high.
Well, leave aside the frankly preposterous. But yes. I mean, the judge does seem to be saying there that there was no assurance that the market conditions mightn't change and lead to O2 coming back into the market with phones.
There are a number of aspects to this. First of all, as far as what ought to have been put to Mr. Swanty is concerned, there are a number of points about that. First of all, Mr. Swanty denied having taken anything at all from the meeting. So it would make no...
Well, that point perhaps is not as strong as...
No, it would have made no point at all to put to him.
But the point about not coming back into the market...
Yeah, it's the wrong way round, in my submission. If you take Solvay as establishing the bar, which must be established, not by me, but by the defendants, they're the ones who've got to satisfy the court with no link, direct or indirect, between the consultation and its subsequent market conduct. That's EE. As far as O2 is concerned, no attempt was made to deal with that at all. Mr. Dunn had gone away, tucked in his back pocket the reaction of Mr. Swanty, and lo and behold, a matter of weeks later, O2 was out of phones for you.
Yeah.
So they didn't rebut the presumption. The judge didn't hold they rebutted the presumption.
No.
And therefore, if there was consultation, as we submit there was, there was an infringement.
Yeah. Is that a convenient moment?
It is.
Okay. Well, about 20 minutes by that clock.
Rob.
Ooh, that's
I've got a list of those.
That's good.
Exactly.
ready on that. I was waiting for someone to say. Sorry? Okay. So you might get some time. Okay, good.
When am I working on Thursday? Yes. When I do my theatre beginning round, I just go straight into
Do you think you yeah, but once you're on.
or should I sit down and then everyone else do their bits and I don't care. You don't have to answer me now, but just
I will probably do that.
like until the
You're
end.
going from 30,
Yeah.
Not a very good answer, so I'm totally don't care.
Who's going to switch off?
Yes.
My lords, my lady, just to recap, we say there are three ways in which the consultation that took place on the 19th of September could have influenced the conduct of EE and O2. And I was addressing you before we broke on the question of direct influence
Well, that
on EE.
O2 is not working at the moment. It's not coming up on screen. What's the problem? Focus. What's the problem?
Sorry, we're having tech issues with the equipment and the computer has shut itself down and is restarting us.
Well, we'll pick this up from live stream, can't we? You can get the rest, you can get it from the stream.
Yes.
So it's up to the transcribers to deal with this. We've got limited time in this case.
I'm sure they will.
And I was quite annoyed when we were delayed coming in this morning by problems with Opus 2 because this seems to happen in almost every appeal they do.
We regret that, my lord.
Well, it's not your fault. It's
do.
a problem with Opus 2, and they've been told more than once, but not only by me, but by the Master of the Rolls and others. Anyway, let's carry on.
Influence on EE. I was addressing the direct influence.
Yes.
We also submit that if there was consultation, there can be indirect influence on EE's conduct, and that arises because once O2 has gone, and if that is as a result of consultation between EE and O2 at the landmark meeting, you can't rule out any indirect link, or at least if you're going to rule out any indirect link, that burden has to be assumed by EE, and it wasn't in this case. They didn't cite to the judge the case of Solvay, and they didn't attempt to satisfy that burden. Now, as we said in our skeleton, once O2 is out, and seems to be staying out, the problem of the prisoner's dilemma is still there, but it's less acute in this sense, that if you know what Vodafone is going to do, and if Vodafone knows what you're going to do, what your intentions are, It doesn't have to be written in blood, just has to be investigated between the parties, then that is an indirect link. Because you'll have seen in the judgment reference to the last man standing, and it's clear that neither Vodafone nor EE wanted to be the last man standing, but they were in that position of being the last man standing, we submit, because of the consultation which had taken place between O2 and EE at that meeting. So that's another way that we succeed, I submit, on causation. And finally, there's another way on causation which we succeed, and that relates to O2's conduct. O2 came to de-risk the decision which provisionally it had taken. It got comfort from Mr Swanty that he wasn't hostile to either the disclosure or anti-competitive conduct, and that's judgment 225. And on that basis, we establish in our submission causation, unrebutted Anic, and certainly not meeting the Solvay test. I then move on to...
well, the judge didn't suggest that O2 could have rebutted the Anic presumption. He didn't suggest that they could have addressed causation or dealt with causation in some different way.
Yes.
So that was...
So, domestic causation, my lords.
Yeah.
If we're right that there was a consultation, and if we're right that there was the Anic presumption was not rebutted, whether by public distancing or by some other means, then there was an infringement. And establishing the existence of an infringement satisfies the requirement for breach of the statutory duty in the Competition Act. But the claimant still has to establish some loss in order to have a cause of action. But the causation analysis for the purposes of domestic law has to be on the correct premise, correct factual premise, both as to what the infringement was, as to the effect of the Anic presumption. And in our submission, on both of those points, the learned judge proceeded in error. And as I'll show the court, his causation analysis continued to assume the form of infringement, which, if the court is with me on ground one, proceeded from the wrong starting point. And then he ignored the effect of the Anic presumption as it affected or bled through into the domestic causation analysis. Now, if we could look at judgment paragraphs 232 to 234. Paragraph 233 is on page 329.
Yeah.
Paragraph 233. If these events gave rise to a concerted practice as a matter of competition law, that's distinct from the question of whether, in fact, O2's decision as regards phones for you was causatively influenced by EE. That is uncontroversial. But then 234, in that regard, I recognise the landmark judgment occurred at a crucial time in the negotiations between O2 and phones for you. One might add, parenthetically, that the whole purpose of the discussion from Dunn's perspective was to de-risk the conditional decision which remained in the balance. The learned judge then proceeds to record, consistently with his judgment in paragraph 217, that Mr Dunn could not have taken from Mr Swanty that EE would support O2. Now, you see that in 234. And if you park the next sentence, Mr Dunn self-evidently did not approach, I'll come back to that. The reference to Mr Dunn not having taken comfort from the meeting is, in our submission, impossible to reconcile with judgment 225. And we therefore need to see what the judge had in mind by looking at what he seems to have thought comfort meant in this context. And that's in the final sentence of the paragraph. For EE to refrain from seeking additional volume of available connections from an indirect channel would be a significant restraint. And Dunn would have appreciated that this would be something that Mr. Swanty would have had to discuss with his colleagues, even if personally he had been inclined to support such an initiative. Now, this again seems to reflect the idea that in order for the collusive meeting to have benefited O2, Mr. Dunn would have had to have gone away thinking it received positive support and indeed some kind of firm commitment as to EE's future conduct, which would require Mr. Swanty to confer with his senior lieutenants before coming to a final decision. But that's at odds with the actual infringement, which we say follows from the finding of fact that Mr. Dunn was seeking to reduce O2's competitive uncertainty. Mr. Swanty's passive response would have told Dunn, and in fact did tell Dunn, in accordance with the judge's findings, that EE wasn't opposed to what O2 was planning to do. And if that was sufficient to found an infringement, then the comfort that Mr. Dunn in fact took from the consultation was what the judge should in fact have included in his analysis, his domestic law analysis of causation. Whether Mr. Dunn in those circumstances would have believed that he had positive support is nothing to the point. There is also the sentence that I skipped over, which says that Mr. Dunn self-evidently did not approach matters according to the legal presumption, but as a matter of commercial reality. What the judge appears to be saying in this sentence is that consistently with his non-application of the presumption, legal presumptions don't matter. But if we are right, the Anic presumption should have been applied to O2 on the facts established by the presumption had to feature in the causation analysis. It had to be assumed that there was a causal connection between the consultation and O2's decision-making process, namely that O2 took the information that Mr. Swanty was not opposed or wholly uninterested in.
Well, that's the point, isn't it?
Yeah.
This is inconsistent again.
Yes.
With 225, albeit 225 is dealing with the Anic presumption, or it's in a part of the judgment which is dealing with it.
That's right.
Anic presumption.
Once
And the judge has found that it doesn't appear Mr. Dunn was left with the impression that he was objecting or wholly uninterested. Then that sentence where he took, if he felt he was clearly opposed, he wouldn't have tried to approach him a second time.
exactly.
So if one turns that round, he must, on that hypothesis, believe that at the very least, Mr. Swanty was not indicating that they were objecting or wholly uninterested in what he was proposing.
Precisely. So when the learned judge came to analyse matters as a matter of domestic causation, his starting point could not and should not have been, would Dunn have appreciated that Swanty had to discuss all of this with his colleagues because he had to have some form of firm support or positive agreement. No, the causation analysis had to start from the facts as found. And the learned judge's causation analysis did not, and that was inconsistent with his findings, inconsistent with the facts which are relevant to the Anic presumption. Now, so what the court could not do at first instance was to identify facts which were, in our submission, capable of giving rise to consultation, and then, when it came to domestic causation, applying a series of facts or tests which was inconsistent with what had been found in J225. So, in effect, what the judge did in our submission, by reasoning in the way in which he did in 234, was to set at naught the facts which had been effectively presumed by the Anic presumption, and that is inconsistent with the principle of effectiveness, which he was obliged to adhere to. So that brings me, my lord, to the end of ground 2. And I don't turn to address the court on ground 3. Now, ground 3 concerns an alleged episode of collusion between EE and Vodafone in 2014. Both EE and Vodafone went through relatively lengthy processes to decide whether they should leave Phones for You. And as I've already submitted, and you will have picked up from the judgment, both of them were contending with the prisoner's dilemma. Nonetheless, as we know, on the 17th of July 2014, Vodafone entered into an exclusive agreement with Carphone Warehouse, which meant that it would not be renewing its agreement with Phones for You. It did not tell Phones for You about the non-renewal until some time later. And as the learned judge found in his judgment, paragraph 391, Vodafone was deceptively stringing Phones for You along in order to try to minimise the likelihood that Phones for You could partner with other MNOs or MVNOs and thereby survive. Vodafone's departure from Phones for You was announced to the market in September 2014. As for EE, the learned judge found that at a board meeting in May 2014, EE decided to negotiate an enlarged deal with Carphone, but did not make any firm decision about a withdrawal from Carphone from Phones for You at that stage. But in August, EE entered into an agreement with Carphone, which was not just enlarged, but exclusive. But that was subject to the approval of the EE shareholders, which was given on the 29th of August 2014. The learned judge found that EE's entry into the exclusive agreement with Carphone effectively marked its decision not to renew its agreement with Phones for You, Judgment 708. So we have Vodafone and EE deciding to leave Phones for You at about the same time. A key question for the court was whether the decisions by these two MNOs were in any way informed by any exchange of information between them. In other words, did one or both of them make their decisions in the light of information which they had obtained about what the other was planning to do? Quite a lot of evidence which had bearing on this question, some of which we'll come to look at under ground 4 and 5. But one of the most important pieces of information was an email which we have at Core Supplemental Bundle 44, page 99. Tab 44, page 99. Now, this was an email from Nicola Talbot to Roger Eyre, dated the 10th of August, 2014. Miss Talbot was referred in the judgment by her married name, Mrs. Derbyshire. She sent this email to Mr. Eyre, who was EE's sales and finance director, and Miss Talbot, or Mrs. Derbyshire, was in his team. Their responsibility was for number crunching, volume and profit forecasts for various scenarios, including staying in or exiting from Phones for You. They reported to a Mr. Milsom and a Mr. Lera. Mr. Milsom was EE's chief financial officer, and Mr. Alera was its chief commercial officer. And if we look at the bottom of the page, the important paragraph begins, Neil. Neil wants us to get this debt completed, but the focus is Phones for You. He wants us to be 100% sure of the impact if Phones for You fold earlier than expected, i.e. in the next couple of months. The expectation is that Voda are about to pull out. He wants us to work with CAM and to be really clear about bills of exchange, offset, claims, prepayments, etc. Now, Mr. Milson's written evidence was that he knew Vodafone's contract with Phones for You was up for renewal in 2014. And that might have explained how he would have known if Vodafone was going to leave Phones for You, it would be doing so in the near future. But what that could not explain is the more fundamental point. Why did Mr. Milson expect Vodafone to leave Phones for You at all? So Phones for You pleaded that this email showed that following communications between the wider EE undertaking and Vodafone, EE gained confidential inside information indicating that Vodafone would quit Phones for You. If we can see what EE said in its defence in relation to this, we can look at call bundle call bundle 2, I think. I've got a wrong reference. It's supplemental bundle 2. Tab 22. That's right. Sorry, forgive me. I was right. Core bundle. Tab 22. It's the core supplemental bundle.
Re-amended defence of the first offender. Yeah.
Page 624. Paragraph 87G, little c, Roman 2. Say that the statement, the expectation is that Voda are about to pull out, appears in an email and not a note. It's denied the statement reflects any expectation held generally by EE that Vodafone was about to discontinue trading with Phones for You. Rather, Ms. Talbot and Mr. Eyre were tasked with developing modelling to support EE's decision-making and therefore required to take into account a large number of possible but uncertain scenarios. The possibility of Vodafone discontinuing trading with Phones for You was one such scenario. So that's what EE said about this. And if we then see what Mr. Milson in his written evidence said about this, we find that in Supplemental Bundle 1, Tab 5, page 133 at 137. And he says there that he's been shown the email.
Yeah.
I didn't know about the email at the time.
Sorry, is
Sorry,
this
my
paragraph
lady.
25?
Paragraph 25.
2025. Didn't know about the email. I had no contact whatsoever with Vodafone or any other time, directly or indirectly, I had no knowledge about their actual intentions. So that's his evidence in writing. EE, in opening, submitted that Mr. Milson's evidence should be accepted, that he had no inside information as to what Vodafone was going to do. In cross-examination, you can see what Mr. Milson said about this. Supplemental Bundle 3, tab 115, page 1429. And if you look at the internal page 135 on the right-hand side towards the top, and I directed him to this email. And I think you say you didn't know about this email until it was shown to you. That's true. And were you surprised when you read it? I was surprised. Why were you surprised? Well, I didn't recollect any such conversation with Nicola. No idea that Vodafone were about to pull out. You had no idea. So Miss Talbot says that you want to have the debt completed, but the focus is on phones for you. You see that? Yes. So that is something that presumably you would have told her. Although you say now you can't remember. Is that right? When I look back over this time, I was conscious we'd spent a lot of time working on Carphone in June and July, and so I can remember that I had been keen to start thinking about the impact on phones for you going forward. Because September would have come down around very quickly. Yes, so I think you can accept. You obviously asked Miss Talbot to do something. Yes, it looks like there was a conversation. Yes, and you're saying you didn't tell her that the expectation was that Voda was about to pull out. I can't remember the meeting, and I don't think I've said that. But you might have said it. Well, I can't remember the meeting, I can't remember the conversation. So, and are you able to help us with where Miss Talbot, where else Miss Talbot might have got this expectation other than speaking to you? I can't say. And then I put to him he was displaying a striking amnesia compared with the earlier evidence which he'd been given in detail and confidently. Now, in closing, we can see what EE said about this, which is in Core Supplemental Bundle, tab 9, at page 45, paragraph 121. Paragraph 122, the email is double hearsay. So Milsom was not copied in on it. Says he didn't recollect any such conversation. Then over the page, Mr. Milsom's account is to be believed, and we don't need to go through any of that. So it was Miss E's case that Mr. Milsom didn't say what was attributed to him. And regardless of what he said, he didn't in fact have any inside information as to what Vodafone was going to do. But the key point is there was no suggestion from EE, whether by primary or alternative case, that Mr. Milsom did obtain inside information about Vodafone's plans, but did so through some lawful means. Nor was any such suggestion made by Vodafone or by any other party. Which brings us to the learned judge's findings in relation to this, which starts at paragraph 602 of the judgment on page 428. So, paragraph 602, Mr. Milsom had been reluctant to give evidence at trial. He had issued a subpoena and served a witness summary, although he later made a witness statement and he gave his evidence voluntarily. But I found him to be very defensive in some of his answers. And in my judgment, he was being less than frank in part of his testimony. As it is apparent from this email, that by the end of the first week of August 2014, there was at least some expectation in Mr. Milsom's team at EE that Vodafone UK would shortly leave phones for you. I consider on the balance of probabilities that this information came from Mr. Milsom, although I think he may have learnt this from Mr. O'Leary. So it appears from judgment 602 that the information that there was an expectation that Vodafone was about to pull out was, contrary to what Mr. Milsom said in evidence, the judge found that he had this information, which could only have been inside information, confidential information, belonging to Vodafone. Now, if one asks, how did EE obtain information about what Vodafone was going to do, the obvious answer would be from Vodafone itself. But if we look at the judgment, the judge decided not to infer that Vodafone's information came from Vodafone, and he gave an explanation why not. And you'll see what he says there in 603. I do not think it can be inferred that any such information about what Vodafone would do came to anyone at EE from Vodafone itself through contact between the two MOs. The Carphone Vodafone agreement had been signed several weeks before on July the 17th. There's no reason why Vodafone would have wished to disclose that fact, which was still confidential to its commercial rival. In my view, there's another equally plausible, indeed more plausible explanation. Mr. Lear had spent much of his time in July working on negotiations with Carphone, which intensified in the days before the two sides reached final agreement. So, as far as the point about Carphone agreement being signed several weeks before, it's the fact that it had been signed was still confidential. The judge was putting forward this as a point which diminished the likelihood that the source of Mr. Milsom's information was Vodafone. We didn't actually submit, and as you'll come on to see, we didn't submit that the confidential information related to the fact of the signing of the Vodafone agreement, nor did anyone else in the case. Our position was that this was reflective of information which had been passed at an earlier date before August. But however much weight one wishes to put to the point that the confidentiality of the signing on the 17th of July, that somehow qualified the possibility that the information was imparted by Vodafone before that date, it doesn't say anything about the possibility that it was conveyed prior to the 17th of July. And one can see, if the judge considered that Vodafone had reasons not to disclose that it had signed the agreement and that it would be leaving shortly, he also obviously thought that it reduced the likelihood that it came from Vodafone. But by that in itself, in our submission, couldn't displace the inference that Vodafone's information came from Vodafone. And the learned judge did not suggest otherwise, did not suggest that it did. Otherwise, he wouldn't have to be looking around for an alternative theory. And that's what he did. The information must have come from somewhere. And nobody, whether in the pleadings, evidence, or submissions, has suggested that there was any other potential source. So, in the absence of any other candidate to convey Vodafone's confidential information, the only possibility would be that the information came from Vodafone itself, presumably based on what the judge had said prior to the 17th of July. And that is the context of what the judge says next. But before we come to that, can we look and put a finger figuratively in that and turn back to judgment 83 to 86 in 284 and 285 of the core bundle tab 18, where the judge deals with standard of proof and evidence required. And in particular, you will see the reference to the Aalborg case, which my Lord the Chancellor has referred to on a number of occasions, particularly paragraph 57. In most cases, the existence of an anti-competitive practice or agreement must be inferred from a number of coincidences and indicia, which taken together may, in the absence of another plausible explanation, constitute evidence of an infringement of the competition rules. Now, as I think the CAT pointed out, I don't need to take you to it, but as a matter of interest, in the CAT, they pointed out that in the original French of this decision, the word evidence was la preuve, French for proof, and indeed that itself in the CAT's judgment is misspelled in the footnote la prévue, but it obviously means la preuve. So what...
Sorry, when you say the CAT, you mean which...
The JJB case.
And JJB's...
JGB, forgive me. I thought I'd said, I apologise for it. So they say a better word might be proof. But anyway, we then go on to 86 of this we see that the judge says this: at the same time, before drawing inferences, the court must be careful to ensure that there is no equally plausible and innocent explanation for the fragmentary evidence on which reliance is being placed. To do otherwise would be to reverse the burden of proof as regards serious allegations. Altogether, I consider the court has to consider the evidence in the round, looking at the particular items of evidence relied in context. So if we then go back to judgment 604, the judge has already put forward a factor which he considers reduces the likelihood that the information came from Vodafone. But the critical question for any given piece of evidence is whether there is another plausible, innocent explanation for that evidence. And if there is no other plausible explanation for a given piece of evidence, you can infer collusion. After all, there is by definition no other way to explain that evidence. Obviously, if there's another plausible explanation, the position is different. And in paragraphs 604 to 605, this is where the judge puts forward what we have called the car phone warehouse theory. If I could invite the court, if you're not already familiar with that, to read what the judge says there. So what we have in 604 is 604 and 605 is this new theory, which the judge accepts was not suggested by any of the parties during the trial. He says it was surprising, but not surprising that no party suggested it, but whether that is right or wrong can't be a relevant consideration. Judge was in no position to know why neither party had advanced the possibility that he found intuitively attractive. He also says he was not making a positive finding that this is what happened. But if, as we submit, was the case, this new theory was determinative of the judge's conclusions in this part of his judgment, it can't matter in our submission whether the judge makes a positive finding that the new theory was correct, because it's clearly determinative of the issue. He says he's identified another plausible explanation for the evidence, which is that the information came from Car Phone Warehouse. And that is what enables him to say that the other plausible explanation, that it came from Vodafone, isn't the correct one, isn't the correct inference, which is appropriate for the court to draw.
Well, what's puzzling is why, if it is the correct explanation, why Mr. Milson didn't say so.
Well,
because the information on this hypothesis wouldn't have been an anti-competitive piece of information.
Well, one can speculate as to why Mr. Milson did not
But assuming
say
that it came from Car Phone Warehouse, gets to Mr. Milson either directly or through Mr. Lalera. And it must have come to Mr. Milson because it's pretty obvious Mrs. Derbyshire didn't get it somewhere else, because apart from anything else, it's in a paragraph in the email which is dealing with her dealings with Mr. Milson whilst Mr. can't remember his name now. Mr. Eyre was away on holiday. So it's all very puzzling.
Well,
yes,
that indeed is one of the opportunities we have been denied to ask questions like this. If this theory had been floated at any stage, either by my learned friends, the opponents, or by the judge himself, and who knows where that might have led. It might have led to the existence of a hub and spoke conspiracy involving Car Phone Warehouse. Who knows? But what is in our submission both unjust and unsatisfactory is for the judge to deal with, on the face of it, an important piece of evidence in this way. The judge says in paragraph 605, this Derbyshire email gives rise to an inference. It was an exchange of confidential, sorry, forgive me. In my view, it is relevant and appropriate to consider the surrounding circumstances against which that issue is to be determined. Well, there's another realistic possibility. But without this car phone theory, the judge doesn't suggest that there was any other realistic possibility other than the fact that it would come from Vodafone, which on the face of it looks pretty likely on the terms of the document. Now, the judge, as we note in our skeleton argument, paragraph 74, reiterated the same point. You didn't look at it. It's at paragraph 38 of his permission judgment, Core Bundle 219, page 473. He referred there to having found in his judgment that it was because of the plausibility of the car phone warehouse theory that, quotes, accordingly, he did not need to find that the information came from Vodafone. This new theory was, in our submission, plainly determinative of the judge's conclusions. It was his conclusion was, his new theory was that it was more likely that it caused him to reject the case. Now, in our submission, it's plain from the judgment and the reasons given by the learned judge in permission that the effect of this new theory was determinative against TFEU on this particular aspect of the case. Key question is, was the judge permitted to rely on this new theory as a basis for rejecting our case? And we submit, based on authority, the answer to that is plainly not. And can I take the court to the decision of this court in the case of Al-Madeni, which one finds in volume 3 of the authorities, tab 9, page 520. Decision of this court back in 2005, Lord Justice Brooke, Lord Justice Tuckey and Lord Justice Dicey, as he then was. Now, this was a claim brought by brought against Mars by one of its employees, Mrs. Al-Madeni. She was a machine operator who was injured when a reel of wrapping paper fell onto her. She alleged that a specific colleague had placed the reel of wrapping paper on the machine. Mars's case was that Miss Al-Madeni had placed it there herself and by her own negligence had caused her own injury. In the course of opening argument, the judge suggested that there was another possible explanation on the evidence that actually a third employee had placed the reel there, so that there was an alternative route to Mars being liable for Miss Al-Madeni's injuries. In closing submissions, counsel for the claimant then adopted this theory in the alternative, and the learned judge found Mars liable on that basis, on the basis of the third person theory floated by the judge. And the Court of Appeal said this was impermissible. And the key part of the judgment given by Lord Justice Dicey starts at paragraph 21. Could I invite the court to read through to paragraph 26?
Yeah.
Now, pausing there, we submit that the approach that the court took in that case applies a fortiori in our case. In Al-Madeni, the learned judge did raise his new theory with the parties, and it was adopted, albeit far too late in counsel's submissions. But in our case, as we know, the learned judge's new theory popped up newly formed when the judgment was delivered in November 2023, 15 months after the judgment, had not featured at all pleadings, submissions, or evidence. Not raised in the course of trial, no witness had the opportunity to comment on the possibility, and no submissions made in relation to it. There's another case which I can refer briefly to, which makes an important point, and that's the case of Ali and Dink, Volume 6, tab 29, page 1354 of the bundle. The decision in the case of Hussein Ali and Dink. Decision of this court from 2022, quorum Lord Justice Green, Lord Justice Burse, and Lady Justice Whipple. And if we turn simply to paragraph 25, the facts don't matter. Could I invite you to read paragraph 25? Now, the key point which we emphasise is that a new point has arisen in such a way that the losing party was not given a proper chance to call evidence or ask questions which could have addressed it. And that is the prejudice which is to be avoided. And we say that is a prejudice which manifested itself in our case. And in the light of these authorities, we say it was plainly impermissible for the judge in this case to deploy his new theory. Now, the defendants have made various arguments as to why they say what the judge did was permissible. And we've dealt with those in our supplementary skeleton arguments, but let me just address a few of them. First, there is an attempt to cast the issue in Al-Madeni as essentially a pleading point. And if we understand the argument correctly, it proceeds in two stages. First, it's said that it's only problematic for a judge to rely on a new theory if that theory had to be pleaded to be legitimately in play. If one of the parties could legitimately have raised the point, despite it not being pleaded, then even if none of the parties did in fact raise the point, it will be permissible for the judge to raise it off her or his own bat. Then the second stage of the argument is to say that the Carphone warehouse theory didn't need to be pleaded to be legitimately in play. Could have been raised by any of the parties despite not having been pleaded. Now, as I submit, the second stage of that argument is very dubious. I've already shown you what EE pleaded in its defence in dealing with this email. We do say that if EE had wished to advance a positive alternative exculpatory theory as to how Vodafone's information could have reached Mr. Milson, the place to do so would have been when EE addressed this email in its defence. That would have enabled disclosure, including potential third-party disclosure, and it would have allowed time for this to be addressed in evidence. But even if I'm wrong about that, and the point could have been raised despite not having pleaded, it wouldn't make any difference. Because as I've shown you, the authorities make it clear that this is not a pleading point per se. The question is one of prejudice and fairness. As Lord Justice Burse explained in the extract from Ali and Dink that I referred the court to, the matter is whether the parties had a proper opportunity to deal with this new theory in evidence, submissions, and so on. As Lord Justice Burse made clear in that case, in answering that question, the pleadings may well be relevant, but they are certainly not determinative. And in this case, in our submission, there was undoubtedly serious prejudice. The phones for you in not being able to deal with this theory and disclosure evidence and submissions. And we've summarised that prejudice in our main skeleton at paragraph 81.3, pages 44 to 45 of core bundle 1 and 3. Now there's a half-hearted suggestion from the defendants that Phones for You was not really prejudiced because they are aware of the possibility that Carphone could have played a role in transmitting the information, and explored that in pre-action correspondence with Carphone, to which we say yes, but following what Carphone said in correspondence, Phones for You decided not to make any allegations against Carphone, nor indeed did any of the defendants make allegations against Carphone. The words of Lord Justice Dicey, in paragraph 21, Nalmadeni or on point, the parties may have their own reasons for limiting the issues and presenting them in a certain way. The judge can invite and even encourage the parties to recast or modify the issues.
Well, you could test it this way, couldn't you? If it had been, leave aside whether it was pleading, if it was as it were, the theory had come up during the course of the trial, whether it had come from one of the parties or come from the judge doesn't really matter for present purposes.
Indeed.
It would have been in the frame.
Yes.
And the very least that would have happened is that you would have cross-examined Mr. Milson about whether or not the information had come from Carphone Warehouse.
Yeah, and possibly other witnesses too.
And other witnesses, potentially, I agree. And his answer might have been, yes, it did. Or it might have been, no, it didn't.
Yeah.
And depending on his demeanour in giving that evidence, the judge might or might not have believed it.
Indeed. And your lordship's already seen from what the judge said about
that he thought
Mr.
he was
Milson
a
in the box.
satisfactory witness.
He wasn't impressed. Let's put it that way.
Yeah.
But
I mean, the whole point there is that we just can't say.
No.
So the prejudice is obvious, really.
Mm.
I mean, what's said against you is, well, this is all really not very important. It's just a bit of sort of market fluff that everybody knew about. That's the sort of line that's being taken, I think.
Well, that's not what the judge said.
One swallow doesn't make a summer.
Well, one swallow doesn't make a sum. That's not what the judge said.
No, I understand.
The judge said there was a plausible explanation. More plausible than the one we had given, and the one we had given is obviously it comes from Carphone. Who else does it come from? It indicates an expectation as to what they're about to do. Now, that's it, Carphone. That's forgive me, my lord. Sorry, I'm getting tired. It came from Vodafone. Who else? Now, one of the points the defendants make is there are lots of other evidence.
We finish at 15:15, Mr. McLean.
Very good.
It's been a long day for you, a long day for all of us.
Apologise for this speaking. I'm grateful to the court.
Unfortunately, we didn't hear whatever it was. It doesn't really matter.
I'm making good progress. I can assure the court.
So I think we finish at 15:15 because it's been a long day.
Now, one of the points the defendants make, there was lots of other evidence which the judge had to consider in reaching a conclusion as to whether they concluded in 2014, and that's quite right, and we'll look at some of that under ground 4. But the suggestion seems to be that that evidence must outweigh somehow what on the face of it appears to be evidence of collusive contact between Vodafone and EE. But the key point for present purposes is the plausibility of our case appears to have been reached in the context of the judge's other findings, which may or may not suggest he wasn't persuaded by us in relation to the existence of collusion. But notwithstanding that, when the judge came to look at this particular issue, it appears that he saw the force in what we were saying, notwithstanding all the other evidence. If that was the only, or if the Carphone was the only alternative realistic possibility for how EE could have obtained this information, and that is stripped away as being not available to the court, then that suggests, on the judge's own approach, that there must have been a collusive exchange. And if that's the position, having established that it was a prima facie incriminating source of or transfer of confidential information, what the court was going to have to do, if it reached that conclusion, was to examine all the other instances of evidence to see whether this threw a different light on it. Now, we'll come on tomorrow to see some of that evidence, but it is quite plain in our submission that if the judge had come to the conclusion, as we say he ought to have done on the basis of the evidence and the submissions before the court, there was an occlusive exchange between Vodafone and EE, and that would have shown a completely different light on some of the other material which was before the court, which the judge dismissed, either as part of a series of unfortunate events, or which took on a different spin. And that's what I propose to say on that at the stage moment.
So you finished ground 3 then?
He says, yes? No, I'm told no. But tomorrow I will be very
His
brief.
master's voice has spoken.
Master's voice has spoken, my lord. It'll be very brief tomorrow.
Very well, with the assistance of your junior, we will. Sorry, I couldn't resist that. So tomorrow at 10:30, and you know that we'll sit through till 2 o'clock, but we will have a slightly longer break probably. So it's probably about sort of 12,
Yes.
same sort of time as we did today, maybe 10, 15 minutes.
We're very grateful to the court, given the circumstances which make it difficult to sit normal hours to have fitted us all in.
Just things we have.
We're very grateful.
Okay, right, 10:30 tomorrow.
What is it?